Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. Video number 1421. We are now discussing case law on the Consumer Protection Act, read with the Limitation Act also. In this case, the Supreme Court, Honorable Supreme Court of India, has to inform the NCDRC that Section 5 of the Limitation Act applies to only appeals and applications, not for the civil suits. Such a pathetic situation. Actually, this should not have happened anyway. When once it happened, then only it comes as a case law. While deciding the case of State Bank of India, of course, this case is like this. Kumar Maity versus State Bank of India and another in civil appeal number 432 by 2022 on 21st January. Supreme Court, two judges bench, Justice Honorable Sanjeev Khanna and Bela M. Trivedi. So, they held that the decision of the State Commission is 100% correct, as well as the District Forum is also correct, whereas the NCDRC is basically wrong, and it is also wrong in advising the party to file a civil suit. How these things developed, let us go to the root cause, that is details of the case. This Sunil Kumar Maity, he is having an account in State Bank of India in Purba, Mednipur, maybe in Bengal. I don't know the correctly. He is having an SBI account, right? Then, on one day, he went to the bank and actually he wanted to deposit some amount, maybe around 500 or so. The staff told him that his account number, which was previously 01190010167, let us not bother about the number. It is changed to another number due to technical reasons or computer thinking. Okay, he has given another number. He has deposited the money. Later, this happened on 24/2/2010, right? On 15/9/2012, after 2 years, he has deposited an amount of 3 lakhs in the bank. And subsequently, by the end of 2012, when he checked up the balance amount, it is only 59 rupees. Instead of 4 lakhs and so, it is only 59 rupees. Then he was perplexed. He went to the bank. He filed a complaint to the bank. The bank told him that there is another person by name Sunil Kumar Maity. He might have withdrawn that amount. All these things they have told. Anyway, they could not recover the amount from him because that Sunil Kumar Maity said he did not receive any amount. A dispute has arisen. Ultimately, the matter was filed before the District Forum, alleging deficiency in the service by the State Bank of India. Here, one important point I want to add. Please remember, had the State Bank of India staff not altered his account number, entire incident would not have happened. That is the main important point you have to recollect in this issue. Therefore, he has filed a case. The District Forum, yes, it has allowed the case and it has asked the opposite party to pay the 4 lakhs amount because the bank is responsible for changing the account number. No doubt, there are two persons with the same name, Sunil Kumar Maity, but the account numbers are different. The bank staff inadvertently or by mistake has written the other number, but willfully I can say, because he said the number is changed. So, your number is not correct, it's a different thing. But here he said the number is changed. Definitely there is some mischief on the part of the bank employees. Whatever it is, so the Consumer Forum, District Forum agreed. Then State Bank of India, not an ordinary institution, they went in appeal. So the SCDRC, yes, the SCDRC also, yes, agreed with the finding of the District Forum. Ultimately, the matter went to National Commission, NCDRC. Here the important issue is coming up. Please be careful. NCDRC has asked the State Bank of India to give a report, a detailed report as to what happened. Who is State Bank of India? It is a party. It is opposite party number one. Opposite party number one is State Bank of India. Number two is Sunil Kumar Maity. Our appellant is Sunil Kumar Maity. Please remember Sunil. So same name. Now the Bank of India, State Bank of India, they have given a beautiful report stating that this appellant, in the name of other person, he has withdrawn the amount. He is himself responsible, self-cheating, all these things they have written. And incidentally, NCDRC believed the version of the State Bank of India and definitely rejected or dismissed the revision. Actually, they have not gone in appeal. They have gone in revision. State Bank of India gone in revision under section 21 of the previous Consumer Protection Act, and the revision was allowed. Okay, so that means the contention of the appellant is not accepted. To that aspect is okay. Then the NCDRC advised that the petitioner, that is appellant, can file a civil suit under section 5, can file a civil suit. At the same time, the State Bank of India advocate said that they will not press any objection regarding the limitation. Who are these people? I don't understand. Now, when the matter came to Supreme Court in the shape of appeal by Sunil Kumar Maity, Supreme Court said, what is this? Did you not go through Limitation Act? Section 3 of the Limitation Act applies to suits. So, bar on the limitation. Suppose whenever a promissory note, if you want to file a case, promissory note, you have to file it within 3 years. After 1 day also, it will not be allowed. Likewise, Section 9 of the Limitation Act says, when once limitation starts running, it will continue to run. It will not stop for you, for the State Bank. And Section 5, it is indirectly meaning Section 5. Section 5, what does it say? Section 5 says that an appeal or application can be allowed even after the period of limitation if reasonable grounds or if sufficient reasons are submitted. So, Supreme Court clearly stated that NCDRC is 100% wrong in giving such a decision. That to revisional jurisdiction is very, very limited for the NCDRC. Anyway, this is a good decision by the Honorable Supreme Court of India, particularly Section 5. Section 5 of the Limitation Act applies to only appeals and applications and not for the civil suits. If you know this much, this will be sufficient. So please read the judgment and enrich your legal knowledge. Thank you very much.